Good day, Crime Talk aficionados. Are you ready for another great show? First, more secret hearings in the Bryan Kohberger matter. This one's regarding the role of the victims. An update on the Sean Combs testimony. The Karen Reed trial gets off to a slow start after the court questions all 18 jurors. 2 stories of a difficult divorce. This day in legal history, our quote of the day, and don't forget our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below, and make sure you hit that bell for notifications of when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps as well. Now, before we get to the docket, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. All right? When you do, you'll be able to do as many background searches as you desire on anyone here in the United States. And guess what? You're going to have a report literally prepared while you wait. It'll be emailed to you, and you can even get updates. And it's going to provide information, for example, on phone numbers, emails, social media presence. You know, why does your spouse or your boyfriend have all of those extra emails that, well, he never asked you to send anything to? Is that because he's using those to sign up for dating apps? You may want to find out. So you're also going to find out if there's criminal history. Are they registered sex offender? Do they have judgments, liens? Are they married? Are they divorced? Go check people out, ladies and gentlemen. CrimeTalkSearch.com. You're going to be happy that you did. All right, let's go ahead and open the record for May 21st, 2025. And guess what? First on the docket, another secret hearing in the Bryan Kohberger matter. That's right, ladies and gentlemen. There's been a secret hearing scheduled today in the Bryan Kohberger matter. And I guess it's really not too secret because we got notice that there was a hearing. We just weren't invited to attend. That's right. The sealed discussion regarding, quote, the role of the victims will be conducted via Zoom today. It was actually already conducted at 11 o'clock. And obviously, given the limited public information and the sealed nature of the hearing, the exact purpose can only be inferred based upon the case context and the standard legal practices, obviously, in a high-profile criminal case, particularly those involving victims of violent crimes. Now, let's do a little bit of analysis. Now, for those who don't know, Bryan Kohberger is charged with 4 counts of first-degree murder and 1 count of felony burglary in connection with the November 13th, 2022 stabbing deaths of 4 Idaho students, for example, or that include Madison Mogan, Kaylee Gonzalez, Xana Kernodle, and Ethan Chapin. Now, the trial is currently set to begin on August 11th of 2025 there in Ada County in Idaho. The trial is expected to last 3 months, and if Bryan Kohberger is found guilty, the prosecutors at this time intend to seek the death penalty. Now, obviously, this case has a lot of public attention that led to a gag order limiting public statements by parties involved in this particular case. And there are multiple sealed filings to protect the integrity of the proceedings. Now, the Judge Hippler, has been presiding over the pretrial hearings, and he's been addressing evidence, admissibility issues, trial logistics, and other procedural matters. Now, the potential purpose of this hearing, the role of the victims, that's always an interesting one. Well, the role of the victims, the phrase role of the victim suggests that the hearing will address legal, procedural, and logistical matters concerning the victims' families, surviving roommates, or other individuals impacted by the crime. Now, given the sealed nature of the hearing and its occurrence via Zoom, it likely involves sensitive and confidential issues that require privacy to prevent prejudicing the trial or violating the gag order. Now, here are, possible likely topics covered. First, could it be victim impact statements and sentencing considerations? The hearing might discuss protocols for victim impact statements, which are obviously presented after the trial is concluded and the sentencing phase if the defendant is convicted. Now, in a potential death penalty case like Kohberger, victim impact statements from the victim's family or friends could play a significant role in the jury's consideration of whether to impose the death penalty or life imprisonment without parole. Now, the court may need to clarify how and when these statements will be submitted, whether they'll be presented in person or in writing, and any limitations to ensure compliance with the appropriate legal standards, right, to avoid a mistrial. The sealed nature suggests discussions about sensitive personal data concerning public disclosure, right? Then we have the Victims' Rights Act under the Idaho law that grants crime victims specific rights, including the right to be notified of court proceedings, to be heard at certain stages of the proceeding, and to be treated with dignity and respect. The hearing could address how these rights will be implemented, particularly for the victims' families or surviving roommates who may obviously testify and want to attend the trial. For example, the court might discuss accommodations for the victim's family in the courtroom, the right to confer with the prosecutors, or the protection against media harassment. The sealed status could indicate discussions about specific families' requests or conflicts, such as ensuring their safety or privacy. Then, obviously, the potential issue regarding the surviving roommates. The two surviving roommates were present, obviously, in the house during the murders, of whom Dylan Mortensen reported seeing the masked intruder with bushy eyebrows. Now, this testimony is expected to be critical, and prosecutors have requested that the live stream be shut down during their testimony to protect their privacy, with only audio permitted. The hearing could also then focus on the role of the roommates as both witnesses and victims, addressing logistic details like, for example, how will they be shielded from the public exposure, their emotional or psychological readiness to testify, or defense challenges to their credibility. Now, the defense has argued that Mortensen's account is unreliable due to being intoxicated and possible, exposure to media. But the sealed hearing would be appropriate to discuss their personal circumstances and safety concerns as well. Now, obviously, this case has been subject to intense media scrutiny, prompting the judge to issue these gag orders governing courtroom conduct, as well as decorum orders, including restrictions on filming, and obviously the gag order to try and prevent leaks. Now, there's, as we've talked about, been some recent releases of information that has not necessarily been made public, and it's a leak. And that leak made it to Dateline NBC's episode that disclosed previously undisclosed information about the case. Now, the hearing might address how the victims' families or surviving roommates will be protected from the media's intrusion at trial. This could also include discussions about sealing certain filings, limiting public access to victims-related testimony, or even managing courtroom seating to prioritize victims' family. Now, like I said, the sealed Zoom meeting suggests a need to discuss these measures privately to avoid tipping off the media or the public. Now, there could also, and probably less likely, the hearing could touch on the victim's family's input regarding any potential plea deal, as Idaho law allows victims to be heard on plea agreements. Now, Judge Hippler has previously directed the defense to provide a declaration by late June or early July regarding any plea offer from the prosecutors as well. Now, if prosecutors are considering a plea to avoid the death penalty, the victims' families might be consulted and their perspectives could be discussed in a sealed setting to maintain confidentiality and to comply with the gag order. However, there is no public indication that a plea deal is actively being negotiated. There's always that possibility. Now, the defense has repeatedly raised the possibility of an alternate perpetrator submitting a sealed offer of proof and facing a May 23rd deadline of providing that proof. A hearing has been set for that on June 18th, and that may also, be discussed. So the role of the victims' hearings could indirectly relate to the defense strategy, such as, like I said, discussions of whether victim-related evidence supports or contradicts the alternate perpetrator theory, and the sealed nature would align with protecting sensitive investigative details and witness identities. So maybe we'll get an order from the court stating what the sealed hearing was about, and if it comes out in the order what the nature of the hearing was about, guess what? I guess it didn't need to really be sealed now, did it? Once again, all these matters should be made public, in my humble opinion. I've never seen anything like this in any courtroom that I've appeared in, and I've appeared in courtrooms across the country where so much is done in secret and privacy. And I think it totally goes against the public's right to know. I appreciate Judge Hippler's efforts to protect the integrity of the proceedings and has obviously been more forthright and forthcoming with information about this case, and particularly the motions and orders. But like I said, you can walk into any courtroom just about anywhere else, and you could hear the most sensitive, revealing things that most people don't want to hear because it's called a public courtroom. And you can walk in and just do that. And just because this is a high-profile case, I don't think it gets special treatment. Let me know what you think, and hopefully we'll find out what the secret meeting is about. Next on the docket, the Sean Combs trial testimony for May 21st. That's right. The 7th day of the Sean Diddy Do It Combs case for a sex trafficking and racketeering featured testimony from Homeland Security Investigation Special Agent Gerald Gannon and forensic psychologist Don Hughes. Now, Gannon detailed evidence from the March 25th, 2024 raid on Combs' Miami Beach mansion, including firearms, drugs, and items linked to the alleged freak-off sex marathons. Now, Hughes provided expert testimony on why victims remain in abusive relationships, contextualizing allegations against Combs. All right. Rapper Kid Cudi's testimony was postponed. Quick recap, though, for Gerald Gannon. He led the raid on the Miami Beach home. The raid involved 80 to 90 agents. The evidence that was found was an AR-15 rifle, parts and defaced serial numbers, a .45 caliber handgun, drugs, which included Xanax, cocaine, ketamine, MDMA, and psilocybin mushrooms. Freak-off supplies, including baby oil, lubricants, sex toys, stilettos, and lingerie. And they were also allowed to show lots of photographs of the seized items, including a bathroom mirror with motivational messages. Noted 6 individuals were briefly detained at the raid, and the defense then cross-examined on firearm tracing methods. Evidence supported allegations of criminal enterprises involving coerced sexual encounters. Now, Don Hughes, the forensic psychologist, was qualified as an expert witness and has testified in several high-profile cases, including the Amber Heard versus the Johnny Depp trial. She testified as a blind witness, which means she doesn't have any knowledge of the underlying facts, but she just wants to come in and talk about what is going on and why people do what they do. It's basically a Psychology 101 class, DV 101 class. I hate blind experts. I hate them. If they have no personal information about the facts of the case and cannot opine as to the facts of the case here, they should not be allowed to testify, but courts allow them to do it. I hate it. It's completely irrelevant. I think I should be able to bring in a blind expert on, the presumption of innocence, the high legal standard of proof beyond a reasonable doubt. But yet, if I were to do that, to come in and just explain what certain things mean, it would be denied. But the government always gets to bring in blind witnesses. It's a complete and total sham, ladies and gentlemen. Anyway, what did the expert say? She explains why victims stay in abusive relationships due to entrapment, love, and the cycle of abuse. The old cycle of violence. That's right. Yes, the cycle of violence. She described coping mechanisms and delayed disclosures, linking trauma to substance abuse. On cross-examination, the attorneys challenged her lack of case-specific knowledge. And obviously, the significance of that testimony was provided the psychological context for alleged victims' behavior supporting coercive claims. Now, like I said, ladies and gentlemen, most of these blind experts, they get up there, and you usually see them, for example, in allegations regarding sexual assault, right? Well, why didn't somebody come forward? They'll say, well, they didn't come forward because they were afraid. They didn't come forward because they felt pressure. They had nowhere to go, right? Or you can get up and say, and wouldn't you agree, ma'am, it could also be because it never happened. Well, that's a possibility, yes. Is it also a possibility that they didn't delay to come forward until there was financial gain to come forward? Well, they'll say, yes, I would agree with that as well. So they just throw it out there. It's common sense stuff, right? An expert witness is something that is not within the general knowledge of the jurors. And so to bring somebody up and say, you're too stupid to understand how things work in life, okay? The victims in the Sean Diddy Combs case could be victims. They were trapped by their circumstances. Or they could be, hey, we enjoyed the party while it lasted. And, well, I grew tired of it and I tried to leave. And, well, and then I went ahead and sued him for, $25 million and he paid out. And there could be lots of reasons for things. So Sean Combs will give him the presumption of innocence. He's got a tough road to hoe. I agree. But blind experts, it's one of my pet peeves in the law, ladies and gentlemen. So thanks for letting me vent on that. Next, the Karen Reed trial, day 20. That's right. On May 21st, the Karen Reed murder trial going on there in Massachusetts hit its 20th day. Now, the day was notable for an unusual procedural issue that delayed proceedings, followed by testimony of two key witnesses, Dr. Azik Wolf, a neurosurgeon, and Christina Hanley, a forensic scientist. Now, for those who don't know, Karen Reed is accused of second-degree murder in the death of her boyfriend, Boston police officer John O'Keefe, allegedly striking him with her SUV and leaving him in the snow outside of a Canton home back in January of 2022. Now, the defense claims Karen Reed was framed in a law enforcement cover-up. So, how did the day begin? The day began with an unexpected delay when the judge announced an unspecified issue requiring individual sidebar discussions with each of the 18 jurors, accompanied by counsel from both sides. The courtroom was cleared, including media, and cameras were turned off during this process, which started about 9:39 this morning. The judge then instructed jurors not to speculate about the issues and to avoid discussing the case while in the deliberation room. No details about the issue were disclosed, but it was noted that jurors' seating arrangements were adjusted afterwards, suggesting, possible juror-related concerns. Anyway, the court resumed about 11 o'clock, and the judge emphasized the importance of jurors refraining from discussing the case outside of deliberations, and due to delays, the morning break was skipped and a shortened 30-minute lunch break was scheduled. Then we heard testimony from Dr. Azik Wolf. He was a prosecution witness. Obviously, he is a Miami-based neurosurgeon, and he was called, taken out of order because of the morning delay. And the good doctor testified about his expert insight into the head injury sustained by Mr. O'Keefe. He reviewed O'Keefe's autopsy, photos, and the chief medical examiner's report, focusing on a laceration on the back of O'Keefe's head. Now, Wolf described the injury as a classic blunt trauma laceration resulting from a backwards fall onto a hard surface, such as the ground. He explained that the skull's impact would cause the brain to move forward, consistent with the observed injury. When asked by Hank Brennan, the prosecutor, if the injury could result from a weapon like a bat, Wolf noted that such an attack would likely cause a depressed skull fracture, which was not present. He also observed raccoon eyes on O'Keefe, indicating a significant injury, but not immediate death. The expert, Dr. Wolf opined that O'Keefe was likely rendered unconscious, but could have continued to move briefly, and he did not die instantly. On cross-examination, the attorneys for Miss Reed confirmed that Wolf's expertise as a neurosurgeon rather than a forensic pathologist. Wolf acknowledged that he does not perform autopsies, but emphasized his extensive experience with brain injuries, stating, "I see more brains than forensic pathologists." The defense attorney sought to explore whether a laceration on O'Keefe's eye would be discussed, but the testimony concluded quickly, ending earlier than anticipated. Now, Wolf's testimony bolstered the prosecution's theory that O'Keefe's injuries were consistent with being struck and him falling rather than an attack inside the home, as the defense has alleged. Then we had Christina Hanley's testimony, and she is a forensic scientist with the Massachusetts State Police Crime Lab, and her testimony resumed from the previous day. Now, she was questioned by the district attorney, Adam Lally, and Hanley detailed her analysis of physical evidence, including a clear glass cup with a broken edge and dirt debris, glass fragments, and plastic debris from O'Keefe's clothing. She testified that 6 of the 9 glass pieces physically fit with another part, while 3 did not. Regarding the plastic debris, Hanley described recovering 1 clear piece of several small red plastic fragments, approximately 1/16 of an inch in size, from O'Keefe's clothing. These red plastic pieces were presented as possible match to Reed's SUV taillight, supporting the prosecution's theory that Reed struck O'Keefe with her vehicle. Photographs of the evidence were displayed, and it was noted that jurors were attentive, with many taking notes. Now, during Miss Hanley's testimony, Karen Reed was observed typing on a laptop at the defense table, indicating obviously her active engagement with the legal team. And the prosecution's focus on the physical evidence, particularly the taillight fragments, aimed to tie Reed's SUV directly to O'Keefe's injuries. Hanley's testimony was ongoing when the court broke for lunch. Now, additional court proceedings in the future, the judge noted that the trial remained ahead of schedule despite the morning delay. Wednesday was the last full day of testimony for this week, and no court on Friday because of the long holiday weekend. Now, the defense team indicated that the prosecution is expected to rest its case by the following week, suggesting the trial is nearing the end of the prosecution's case in chief. Then we'll get to see what Karen Reed has to put up. Now, remember, the defense never has to put up any evidence. The defendant does not have to prove herself innocent at all. And the reality of it is that the motion for judgment of acquittal that will be made after the prosecution rests will promptly be denied. So the question is, will the defense try to go forward with the alternate suspect theory that Mr. O'Keefe was beaten inside by police officers and the grand conspiracy cover-up took place that they were able to present in the first trial, to see if they want to stick with it in the second trial? It's going to be interesting. And then obviously the most important thing will be, will Karen Reed testify? Now, her video interviews from all the news media over the last several years have been being played throughout the process as a little reminder that she admitted to driving the car. She admitted to being drunk. She admitted to being upset, admitting to saying, well, maybe I hit him. And if I did say I hit him, I only said it once, not 3 times. We'll have to wait and see. I cannot wait for the defense case in chief. Next, a couple of cases about some real tough divorces. That's right. An Arizona man faces charges in his estranged wife's death. Brandon Gregory has been charged in connection with the death of his estranged wife, Allison Gregory, following a violent altercation at their residence in Surprise, Arizona. The incident, which culminated in Allison Gregory's death, has led multiple charges against the suspect, including second-degree murder and manslaughter. So what took place? Well, it's alleged that back on May 14th, 2025, the Surprise Police Department received a missing persons report for Allison Gregory after she failed to pick up a family member at the airport. Police noted that Allison and Brandon Gregory, though living together, were navigating a contentious divorce. Upon investigating the home, police observed evidence suggesting a physical struggle had maybe taken place. A little further investigation led authorities to locate Allison Gregory's vehicle at Burrow Creek Campground in the Mojave County, where Brandon Gregory was found with the vehicle. Tragically, Allison Gregory was discovered deceased in the back seat. Now, according to court documents, Brandon Gregory admitted to engaging in a physical altercation with his wife after an argument escalated, and he alleged that Allison kicked him in the genital areas while holding a wooden bat, which he then seized and used to strike her multiple times. Anyway, Brandon reportedly attempted CPR on his wife, but was unable to revive her. And according to the arrest affidavit, it indicates that he then wrapped her body in carpet padding, placed it in the vehicle, and cleaned up some blood from the scene. He's also accused of disposing of Allison's cell phone, her Apple Watch, and the wooden bat, the latter of which was discarded in an open field. Now, during a search of the vehicle, police recovered an apology letter addressed to Gregory's children in which he sought forgiveness for his actions. Well, where did all that lead us? Well, Brandon Gregory was arrested and booked into the Maricopa County Jail. He faces charges of second-degree murder, manslaughter, tampering with physical evidence, and concealment of a dead body. The investigation remains open as they continue to go through the evidence and statements related to the case. Tough divorce, ladies and gentlemen. Well, let me give you another one. We go from Arizona Let's jump over to South Carolina, where a woman is charged with the murder of her ex-husband there in Myrtle Beach, South Carolina. Joanna Vassant faces charges of murder and possession of a weapon during a violent crime following the death of her ex-husband, Frederick Vassant Jr., there in South Carolina. The incident, which apparently took place back on May 16th, has left the community shocked and raised questions regarding the circumstances leading up to the alleged crime. But what do we know? According to the police, they were dispatched to a residence in the Burgess community at approximately 10:20 p.m. on May 16th, prompted by a report of a suspicious white Honda truck parked outside the home of 60-year-old Frederick Vassant Jr. Upon arrival, officers observed no lights on inside the residence, and when they knocked on the door, Joanna Vassant answered, visibly covered in blood, despite no longer residing at the residence, according to the arrest affidavit. And also, according to the arrest affidavit, Joanna made an excited utterance to officers stating that the victim was in the back of the house and that she had changed her clothes because they were soaked in blood. Officers noted a significant blood trail throughout the home, which led them to the locked porch closet. And what did they find inside the locked porch closet? That's right, the body of Frederick, who had sustained a fatal gunshot wound to the head. Evidence of the shooting was also found at the scene. Needless to say, Joanna was immediately detained and booked into the detention center, where she now faces charges of murder and possession of a weapon during a violent crime. The judge denied her bond at a hearing on May 18th, citing the severity of the charges and the circumstances of the case. Well, turns out, Joanna and Frederick were previously married, but they divorced in 2021. And according to the South Carolina Department of Social Services, records confirm the dissolution of their marriage, and land records showed that Frederick owned the townhome on the Dinger Court where the incident occurred. Joanna, who now resides at a separate address in Myrtle Beach area, had no legal residence at that property, according to the police. They've apparently come up with no reason, no motive for the alleged crime, and the investigation is ongoing. And of course, the police get out there and say, "Hey, understand? We believe we've solved this case. No reason for everybody to be alarmed. The real suspect is in custody." And then we have on the docket today, this day in legal history. On May 21st, 1872, the Amnesty Act passed. That's right. Congress passed the Amnesty Act, restoring voting rights to most former Confederates. It reshaped the Reconstruction-era legal policies and reduced treason prosecutions after the Civil War. And on this date in 1957, the Civil Rights Act debate begins, and Congress was debating the Civil Rights Act of 1957, passed in September. It created the Department of Justice Civil Rights Division, strengthening federal enforcement of voting rights. And on May 21st, 1974, the Watergate Special Prosecutor subpoenas President Nixon's tapes. That's right. The prosecutor subpoenaed President Nixon for Watergate tapes. The resulting case, United States v. Nixon, set the precedent for executive privileged limitations. And on May 21st, 1998, the Unabomber, that's right, Theodore Kaczynski, was finalizing his plea agreement, receiving life without the possibility of parole for a bombing campaign. His case obviously was considered and classified as domestic terrorism. And then the legal quote of the day: "The law demands that no one be convicted unless guilt is established beyond a reasonable doubt, ensuring that justice prioritizes certainty over conjecture." Good quote. That was from the Winship versus United States case decided in 1970, emphasizing the constitutional necessity of proof beyond a reasonable doubt in a criminal conviction. That's right, proof. Not conjecture, not speculation, proof beyond a reasonable doubt, ladies and gentlemen. And finally, our dumb criminal of the day. On Monday evening, deputies conducted a traffic stop in Florida after observing a vehicle displaying a cardboard license plate with the word private. The driver, later identified as Benjamin Adam Roach, reportedly claimed he had no identification. However, a birth certificate found inside the vehicle confirmed his identity. During the search of the car, deputies located some meth, some drug paraphernalia, and two suspicious cylindrical objects. One object was a PVC pipe with caps on both ends, and the other was a cylinder wrapped heavily in black electrical tape. When questioned, Roach allegedly admitted that the objects contained gunpowder. Initially denying the presence of a fuse, he later acknowledged that one of the devices had a fuse. Guess what? Bomb squad shows up. The discovery of the suspicious objects prompted the involvement of the bomb squad, needless to say. Hey, and let's bring in the ATF as well. After a thorough investigation, the bomb squad confirmed that both objects were functional pipe bombs and safely disarmed. Needless to say, Mr. Roach was arrested and transported to jail, where he is being held with manufacturing a bomb, possession of explosives, possession of controlled substances, tampering with evidence, possession of drug paraphernalia, as well as a sundry of other additional crimes like, no valid license plate. Anyway, once again, no motive for Mr. Roach. But Mr. Roach, you are a dumb criminal. Hey, let's face it. Who doesn't have the urge to build a pipe bomb occasionally and drive around with a car? But if you're going to commit crime, please don't give the police officers reason to pull you over, like having a fake license plate where you write in the words private. That is reasonable suspicion to make contact with you. Now, maybe there's some search issues on the whole car thing, but I don't see a judge throwing out that search unless it was just completely unreasonable in violation of the Fourth Amendment. Anyway, Mr. Roach, you are a dumb criminal today, not for the pipe bombs, because, hey, we've all been there, right? Haven't we? Yeah, right. Anyway, so you're there for the false license plate. Anyway, thanks for watching. We'll see you next time. And remember, the Constitution matters.